Hi, my name is Steve Flores, and I'm a partner at the law firm of Winston & Strawn, LLP. I focus my practice on employee benefits and executive compensation. I'm also the immediate past chair of the ISBA Section Council on Employee Benefits. Today, I'm going to talk about fiduciary obligations that apply to employers who maintain qualified retirement plans, such as a 401k plan or a pension plan. The Employee Retirement Income Security Act sets minimum standards for individuals who oversee such plans. This is important for you to understand because individuals and employers who oversee such plans have increasingly become the subject of litigation. In addition, ERISA imposes personal liability on fiduciaries who breach their obligations and as a result cause losses to a plan. First, I'll explain what makes someone a fiduciary under ERISA. Second, I'll discuss some basic fiduciary obligations. And third, I'll discuss some steps you can take to protect yourself and your clients. So who is a fiduciary under ERISA? Generally, a fiduciary includes a trustee, an investment advisor, investment manager, a named fiduciary who's included in the plan document, individuals who oversee the operation of the plan. This can include the board of directors. It can include executives, HR representatives, committees, and individuals who serve on those committees. Importantly, anyone who delegates or appoints another fiduciary is also themselves a fiduciary. So what are the basic duties that apply to ERISA fiduciaries? First, there's the duty of loyalty. This requires that fiduciaries act solely in the interest of participants and their beneficiaries for the exclusive purpose of providing them benefits. Second, there's the duty of prudence. This means that fiduciaries must act prudently when making fiduciary decisions. This generally requires a prudent process or a robust process when engaging in a decision. If a fiduciary is not an expert in a particular area, he or she must go out and engage a professional to assist them with that fiduciary decision. Third, fiduciaries must act in accordance with plan documents. Fourth, fiduciaries must diversify the assets of a plan so as to minimize the risk of large losses. A fiduciary must also only pay reasonable expenses from a plan. And finally, fiduciaries must avoid engaging in any prohibited transaction with parties in interest to the plan and in engaging in any self-dealing transactions. There's other obligations, but these are the basic fiduciary obligations. So what steps can be taken to protect ERISA fiduciaries? First, fiduciary obligations can be delegated to individuals, committees, and outside service providers. By doing this, a board of directors or a committee can limit their fiduciary obligations to the selection of such persons and the oversight of such persons. Doesn't get rid of the obligation completely, but it limits it. Second, employers should review their insurance policies to make sure that there is sufficient coverage for fiduciary liability, and also to ensure that there's no gaps in coverage. Importantly, the ERISA bond is not the same as fiduciary liability insurance. That ERISA bond is intended to protect the plan, not fiduciaries. Third, and most importantly, employers should establish robust practices and procedures to ensure compliance with fiduciary obligations. This means training your fiduciaries, making sure that policies and charters are up to date and accurate. It also includes keeping robust minutes of any decisions that are made that are fiduciary in nature. This includes minutes, it includes presentations that are made to the fiduciaries, bios and other materials that demonstrate the qualifications of service providers, and regular meetings for any fiduciaries who oversee, in particular, plan investments. ERISA does not require perfect outcomes, but it does require a robust process to reach all decisions. To learn more about the benefits of joining our ISBA Employee Benefits section, please visit the ISBA website.